if you find them helpful. There we go. Any other quick questions before we officially start? It is so good to see you all. I am going to record, just a quick note, I do always record class. So if you ever miss it, just let me know. I can easily send you the file or share it with you if there's any part you wanted to go back over. But it's great to see you all. I want it just as a note of disclaimer. I think these 2 first weeks are the least exciting in terms of using an online. There's so many great ways to learn online. There's great benefits of online learning where it's more engaging, where everyone is participating, you're applying concepts. The truth is, I honestly I love teaching online and I have a lot of excitement about it, but I really don't know how to make this material fit in a true online class. So I just bear with me for 1 more week, and starting next week, this will be a very different space. So starting next week, our entire time together will be practice problems. We'll be practicing an old exam together. We'll be practicing some smaller con law questions. We'll be practicing applying grounds for divorce. So the way, just as a reminder, the way this will ordinarily work is whatever you did in class the prior week. So this week you're learning grounds for divorce and fault-based grounds and defenses. Next week in class, that's what we will apply. So you're always free to work at the material. If you haven't even looked at the material for this week, that's totally fine. We'll always be using this as a tool. Spaced repetition is a great learning tool to come back and apply things after you've already learned it. So we try to seize that in the online space. So we will move, though, pretty quickly again today. My words of advice, I got a lot of great emails from you guys offline this week offering suggestions about what's working, what's not. We're covering very murky concepts. And so the key thing I want to lead with is a reminder that when you're taking the exam, murky is your friend, because you don't know what the question is, but you know that anyone challenging a law is going to want to use the frameworks that give the highest level of scrutiny. Anyone defending the law, the state defending the law, is going to want to pick and cherry pick the cases that give the least scrutiny. So for our purposes here, try to liberate yourself away from getting the answer. What is the right to privacy? What is the definition? What are the standards? And instead start to group which law is the best for a challenger to use, something like Whole Woman's Health, which law is something for the state to use in its defense, something more like Gonzalez. So just as a quick review of our material last week, we introduced the right to privacy, and we introduced the right to privacy first in the Griswold case. And the Griswold case, we very carefully built a foundation, each of the little pieces that come together to make the right to privacy in Griswold. We built from Meyer to Pierce to the Brandeis brief, and we left Griswold with the sense that there is a right to privacy, but not a lot of clarity about what its contours were. We then moved, the only thing we knew is that it was a marital right. It sat in the marital relationship. So then we moved to Eisenstadt, and Eisenstadt breaks that apart and says whatever the right to privacy is, it's held by individuals. It doesn't sit in a couple. And then we moved to Roe, and Roe also in a murky way said whatever this right to privacy is, whatever its boundaries are, the right to privacy is broad enough to include the right to terminate a pregnancy. And Roe also shifted the constitutional home for that right to privacy to the 14th Amendment, where we will house it. I often get asked, what do we need to know or do with that historic context? I want you to keep that in mind. It fast forwards us almost to Thomas's opinion coming up later today, where he says, every time we talk about the right to privacy, we talk about it differently. We change the standards. And that is a very fair critique. So I want you to keep in mind that it has ping-ponged from this penumbra to this 14th Amendment substantive due process. Next, because the contours of the right to privacy are so murky, we're left wondering, what is this really about? What are we actually trying to protect? We're trying to regulate how the state regulates the family. We're trying to create boundaries around how the state regulates the family. But what's at stake? Why do we care? What value are we protecting? Well, there are a couple of cases that we've studied so far that say we're protecting decisions. The decision between a doctor and a patient, or an individual decision to use contraception, or the decision of a couple to use contraception. There are others that say we're protecting relationships, the doctor-patient, or the marital relationship. Later on in the course, we'll develop more the parent-child relationship. And today in Lawrence, we'll develop intimate relations as a relational conception of the right to privacy. There are other cases, though, that we looked at that say this is really about space, like privacy, more like Justice Brandeis said, like get your paparazzi out of Samuel Warren's daughter's wedding. That's what Justice Brandeis was really protecting. So saying that there are certain no-go zones where the state should stay out. But those are very different. And I hope when you read the material for this week with these frames in mind, you can kind of see it shifting, like in Lawrence. What is the court really upset about? Is it upset that the police came in and saw intimate conduct and that the state used its power in this way? Or is it upset that two people consented to come together in an intimate act and the state criminalized it? Like, what is this really about? So that's where we are today. I also want to do just a quick both review and preview of our material today. Last week, we sort of talked about how to do constitutional analysis, but more of our time was spent on building out these rights. Today, my goal for us is to tighten and refine the rigor with which we talk about these constitutional claims. So I encourage you to follow this, and this is straight from the slide that the video that you watched last week. But for our purposes, we're looking either for a classification or a right at issue. I should have been a little more careful here. And then after that, it's really a two-step process. We ask ourselves, what is the government's objective? Why did it do what it did? Why does it ban child support debtors from marrying? And then how did the government try to achieve its objective? If its objective is to get counseling to debtors to children, then the means chosen should somehow advance that objective. And if they go way broad and sweep in too much, it might not meet constitutional scrutiny. Or if they go way under and scoop in too little, it might not meet our constitutional scrutiny. So another way to look at it, if you like charts, we all know I love charts. I like to think about it this way, as a two-step test, that we're looking to determine the government's objective, and it has to meet one of those three off of our menu. Then we look at whether the means chosen meet our test. So that's the way the constitutional lens you're going to apply. And that's the lens we would ordinarily be using when we talk about abortion, based on Roe. So when we studied Roe, Roe said that the right to privacy includes the right to terminate a pregnancy. Now, I want you to listen really carefully as we talk about this abortion material today, because we have a case before the Supreme Court right now, and we obviously have a huge looming national political legal question of what is the future of Roe. And so I want you to watch what's happening here, because I think it's transformative. So what we're going to, and you can see it better this week than you could last week. What we're going to see here is the pulling out of abortion and giving it, you can almost think of it as like putting it on an island, giving it its own lens, its own test. So if you were making your outline, you'd have the right to privacy, which we've studied, which will include Griswold and Lawrence and Obergefell and all the cases we'll study today. But then abortion after Casey kind of goes othered. It becomes its own category. And so the Casey case, which we notably don't read, but it is discussed. And one of the reasons we don't read it is it was only a plurality. So the plurality of the court said that the test we should use is to look at whether a state regulation imposes an undue burden on a woman's ability to make a decision whether to procure an abortion. The next question is, what is an undue burden? An undue burden is one that has the purpose or effect of placing a substantial obstacle in the path of a woman seeking an abortion. And so here, just to get right to the chase on your exam, this is the test that you will apply. But the question is, what the heck is this, right? We just studied the right to privacy. I just told you that the way we think about the right to privacy is through this constitutional lens, and the court detours us. So the question framing the next few minutes of our discussion as we go through Gonzalez and Whole Woman's Health, the question framing it is, what is this undue burden test? Is it like strict scrutiny, which we had close to in Roe, but not exactly? Or is it something closer to rational basis? And I hope what you're going to take away from this is a sense that it's a ping pong, that it's a little bit of, it's fluctuating unequivocally, regardless of your politics. Justice Thomas is right that every time the court talks about this, it talks about it in a different way. We can disagree about what way the court should go, in your opinion, but really you should leave this with a clear sense that this is a moving target. So that brings us to Gonzalez. Now, a quick apology to all of you. I thought I was doing this really great thing by allowing the 6th edition of the casebook to stay because so many of your classmates have it and you could get it super cheap. And the 7th edition was harder to get. But then I created confusion because there was no one in the class who read both. If you used the 6th edition, you would have read Gonzalez, but not Whole Woman's Health. And if you had the 7th edition, you would have read Whole Woman's Health, but not Gonzalez. So for our purposes, we'll move through them with that in mind, understanding that. So to set up Gonzalez, we left Roe with a sense that there were 2 government objectives that prompted the state to regulate access to abortion. 1 was legislating in the interest of maternal health, and 2 was legislating in the interest of protecting potential prenatal life. So I have Ethan and Juanita on call for this. Did both of you guys read this case, or did you find it one way or another?
Yeah.
Okay. I did read it.
Okay, great. So let me start with Ethan, why don't you go first? So why don't you tell us what the statute is here?
The statute is Nebraska's partial birth abortion statute, and the petitioners were saying that it violated the federal constitution under Planned Parenthood, Southeastern Pennsylvania versus Casey, and Roe v. Wade. Congress passing the partial birth abortion ban act of 2003. I'm also working through it online here.
I know one of the things we're all struggling with online learning is how to manage our notes and the screens. This is a work in progress for all of us. Yeah.
I will tell you, has that define what you needed to know, or do you?
I'm good. Yeah.
Okay.
Yes, good. So in short, and because we're not really studying the abortion piece of this access on its own, what we're really using this is it's a train stop on our way to understand the right to privacy. So we won't go in too much to the details of this as it relates to abortion and the access issues, but it basically bans one form of an abortion. And it was only a facial challenge, which is interesting because, or not only, it was a facial challenge, which means there's no plaintiff, which is important. So we don't have a story or a person or a context in which to read it. But what I want to do now is I want to do what I'm calling my all-ins, where everybody participates. And if you have read this case before, either in con law or if you read it for today, I want in the chat for you to comment on the rhetoric of this piece, not for political reasons. So I don't care what you actually think about the rhetoric, but specifically in the lens of what we've talked about with the right to privacy. What is the rhetoric doing? It's a very graphic case, unequivocally. But why? Like, what goals does that serve? It's written by Justice Kennedy. It was written by Justice Kennedy while, well, anyway, but what is it serving? What does it do to the right to privacy? So take a minute, especially if you read it in con law, you might have already teased out some of these themes, but what does it accomplish? It's really significant to understanding the right to privacy. And it's really significant to understanding these dual purposes. Good. So our first two responses are both, it's definitely taking a position that this procedure is immoral, this procedure is unethical, this procedure defies the ordinary medical doctor-patient relationship. There's a huge emotional appeal from it. What does it do to motherhood? What does it do to personhood of the fetus? And what does it do to the doctor-patient relationship? Good. So first, Monica tells us that it's highlighting a person aspect. If you remember back to our Roe case, the court in Roe said, we are not taking a position on this, on when life begins, because if nobody can agree on this, we're not going to agree on it now. And the court here is unequivocally not taking a position either, but the court is unequivocally personifying the fetus. And that's important, not for political reasons. We're not here to talk about politics. We're here to talk about law. And the reason it matters is if we go back to Roe, there were two purposes: maternal health and potential prenatal life. The reason it's so insignificant that it is personifying the fetus is because of those two interests. It's definitely bumping prenatal life higher than it was in Roe, whether it means also higher than the mother, and Juanita tells us this. Juanita, you took your thunder out from yourself. And the next question I was going to ask was, why did it even pass the law? It passed the law to protect fetal life. It unequivocally, of the two ways the state could regulate, picked one and regulated exclusively for that purpose. So we position it as a person. What does it do to the doctor-patient relationship? If we think back to privacy through the lens of relations, how does it cast it? Because in Roe, it kind of buttressed it and said, this is between a doctor and a patient, and we're out of it. You do your thing and make whatever decision is right in that medical context. Here, what do women need to be protected from, or who do women need? What is maternal health here? Anyone in the chat? How does it portray? Yeah, TJ says it good. This is to the extent, if we think about the dual purposes, maternal health and protecting prenatal life, the interest in protecting maternal health shifts dramatically here. The court is unequivocally saying that what pregnant women need to be protected from is their own doctors, who might not tell them just how graphic this decision or this procedure is. So if we think about our relational context here, we're totally reframing from Roe to here the idea of this private doctor-patient relationship, and here we're clouding it with suspicion. And so there's lots of important narratives happening here. And so Roe and Gonzalez are often discussed as two total extremes: the high water mark, where Roe got the closest to a fundamental right, and the lowest level of scrutiny were in Gonzalez. So let me come to Juanita. What does the court ultimately do with the statute? Let's follow our methodologies. What was the stated purpose for enacting this law, and do the means selected pass constitutional scrutiny?
Okay, I am not an expert, and I'm not sure that I totally understand the question.
Let's do it one time. First of all, why did the government enact this law? I asked you like 4 questions at once.
Okay, so they enacted it to protect the baby, the prenatal life. Mm-hmm. So I think that was the purpose of it: preserving and promoting fetal life.
Good. And the sort of ethics of the medical community as well, trying to, and one other thing we didn't talk about is the way in which the court describes them as abortion doctors. They're OBGYNs, they're licensed doctors just like anybody else, but there's definitely an othering, that this is a different kind of medical context. Good. So the next question we ask, and I think it's helpful to say it out loud, even if it's a little obvious, is what means, Juanita, did the state choose to regulate? So what does the law do to try to protect life and dignity of life?
Well, it limited it, made illegal this one method of late-term abortion. It left in place other D&C operations and what is it called? Injections. Mm-hmm. So it didn't take away. It was just this method that it limited.
Good. And what standard of review, Ethan, let me come back to you for a second. What standard of review did the court apply here in looking at the constitutionality of the statute?
Sorry, I was muted. Can you repeat your question again?
Yeah, what standard of review does it apply here? Is it the Casey standard? Is it Roe standard?
They applied the Casey standard, the three-part, three premises of Casey, that the state from the inception of pregnancy maintains a regulatory interest in the life of the child, and it can't be set aside for a health exception.
Good. So if we go back to our Casey standard, you can see why our casebook editors don't put Casey in here, because Casey was a plurality. Gonzalez is a majority. And in Gonzalez, the court, or in Whole Woman's Health, if that's what you read as well, the court adopts the Casey standard as the governing standard for the question of whether a state law improperly regulates access to abortion. So this tells us that Casey is the standard. And then as Ethan expressed, the question is, does this method, so Juanita tells us the method is to ban one type of abortion, does that further the government's interest in protecting prenatal life? And the court says yes and strikes down the statute. What does, Drew, I think I have you on call for this. What does Justice Ginsburg have to say? She makes a couple of important points, and particularly here focusing on the right to privacy. What does she say the court did, Drew, to the doctrine that we studied from Roe?
She kind of talks about how they just aren't caring about women's safety at all. They're making a regulation without recognizing what doctors have to say about that this procedure may be necessary for maternal health.
Good. And you can kind of see, if any of you happen to actually read both of the cases, if not, I hope if you only read Whole Woman's Health, you can kind of hear Ginsburg's critique in the dissent is answered in Whole Woman's Health. But she's saying, look, there were two stated government interests in Roe, and we were delicately balancing them. Here, we lost maternal health entirely. And so what if, she says, what if there are circumstances where this is the only procedure that would work for, shouldn't we have exceptions for maternal health? Good. And then what does she say? So the question that is always hovering when we talk about abortion is, what the heck is this test? Is it rational basis? Is it strict scrutiny, or is it something else entirely? And what does Justice Ginsburg, Drew, say this test is?
To be honest, I'm not sure.
Anybody help us out? Does she think that it is too high, too low? What does she think about what the court's done here? Roe got really close to strict scrutiny, but it didn't quite get there.
Would this be more like strict scrutiny because they're going after such a narrow aspect as it relates to it?
No, it's more like rational basis because they're so deferential. So anytime you're looking for, especially for all my 2Ls, anytime you're looking for to do a rational basis test, you're giving the state. So here the state of, I forgot what state it was. Here we're giving our state great deference. So we're saying, well, if you think this is a rational way, then it's probably good. For strict scrutiny, we're gonna chisel and make sure we have a really carefully defined law. So she's saying that this is effectively rational basis, and that sets us up for our move into Whole Woman's Health. So our takeaways from Gonzalez, let me use my slides here to help us through. Our takeaways from Gonzalez, it applies the undue burden test. So for your exam purposes, you can cite to either Gonzalez or Whole Woman's Health for the Casey standard. And then the language that it uses is unequivocally languages of legitimate, that the government's objective in protecting potential life is legitimate. And she's saying, hey, that's rational basis. That's a big move that we just made, and she wants to call the court out on it. And that her point really reinforces Justice Thomas's point that every time we talk about this, we change the standard. And at this moment, Justice Ginsburg is agreeing, I think, with that. But it ultimately upheld the statute. Okay, next let's look at and then some of the rhetorical points, that it shifts this idea of the medical profession from a trusted advisor to something else. It shifts the state's interests, and I think Holly had a point about that in the comments, that it makes the state protective, almost paternalistic of women's health in a very different way. So lots of takeaways from Gonzalez. So then we move into whole woman's health. And so we're left with this critique where Ginsburg is saying, hey guys, you just used rational basis. That's not what the test was in Roe. So let me turn to Teresa and Monica now. So Teresa, do you want to tell us what the underlying law was in whole woman's health in Texas?
Yeah, so in Texas, there was a law that said in order for a doctor to perform an abortion, he must have admitting privileges at a hospital that is not further than 30 miles from the clinic that he or she operates from, and that the facilities that the OBGYN is operating in has to meet the state standards for ambulatory surgical centers.
Good. So 2 laws, and just generally speaking, what was the effect of these 2 laws? What happened in Texas after they were set to go in effect?
Well, Texas is a huge state, so having that 30-mile radius is a really short, it's not really feasible for most of the clinics that are in parts of Texas that aren't near a big city. And that was for the admitting privileges part. And then the second part, which is the state standards for ambulatory surgical centers, it restricted, or it made it really hard for these OBGYNs to have these really high standards, because I think 90-something% of abortions are done without needing to operate. So it would be a waste to make them have a state-of-the-art surgical center for something that is hardly used, and that made it really difficult for OBGYNs to meet that standard.
Good. This is usually the part in class why I get real uncomfortable and drag it out for several minutes and make someone actually say out loud that it's a natural opening. When surgery requires surgical openings, it's a natural opening. Important context for what we're talking about with surgical centers. What does the district court strikes these 2 statutes down, and we won't talk about that now. We'll talk about what the Fifth Circuit did, because it's going to look a lot like Gonzalez. And so let me switch to Monica. So Monica, what does the court do with what does the Fifth Circuit do? How does it describe the test, and what does it do to the 2 provisions?
The Fifth Circuit would it be the time when this case was actually brought, right? Not when a similar case came through with the injunction on the law.
Yeah, so just in this opinion itself.
So the Fifth Circuit applied a test that was not necessarily the test of Casey, and they got called out for that. I can't remember the exact test. I think it was they looked at a balance instead of that undue burden or the obstacle that's placed on the right to access an abortion. That was the one that was taken.
Good. So it says that that a law is, so it upholds the law and says that they are unconstitutional if they don't have the purpose or effect of placing a substantial obstacle. That's our KP language. And it's reasonably related to a legitimate state interest. So the Fifth Circuit, if it were to respond directly to Justice Ginsburg and Gonzalez, would say, yeah, we are applying the rational basis test. That's what we are doing, which would be significant because it would mean that most laws regulating abortion would be found to be constitutional. And so on appeal, what is, Teresa, let me come back to you. What is the court concerned with? How does it fix the test that the Fifth Circuit had applied? What was missing from the Fifth Circuit's analysis?
Was it the undue burden?
Good, an undue burden.
The woman would face.
Good. So what does the court want Texas to look at instead of just whether it's legitimate or rational?
It wants it to kind of prove that it is, that the laws are reaching that interest, and then it decided that it didn't because there's a really low rate of complications and almost no deaths occurring with women who get abortions. So it didn't further the interest of women's health. Good.
And the court, it's so poetic that this case is called Whole Woman's Health, because if we follow it from Gonzalez, Ginsburg is saying, hey, this is the first case we've ever decided where we've completely jettisoned women's health from the two-part test multi-pronged interests, where we were looking at both women's health and potential prenatal life, both of which were valid state interests. And here the court is saying, we do need to look at women's health, and it's doing, and in the interest of time, we won't go through all the details, but Monica and Teresa have nicely summarized this case. There's a very detailed case if you haven't read it. But it really reads like a straight up cost benefit analysis, that if this is supposedly about women's health, the reason you're doing this is to make a procedure safer for women, then you need to consider not just the burdens, like how many clinics would close, but also the benefits. What would this actually specifically do? And here you have this massive imbalance. The very small number of cases that would actually benefit from admitting privileges and ambulatory surgical licensing requirements, and a huge number of clinics that would no longer serve women at all because of this. And I'll note, just in the interest of time, that the court does have notable concerns about causation, about whether the plaintiffs, the petitioners, adequately proved that the reason these clinics closed were because of these two laws. But for our purposes, though, we can see like a real pendulum moving here, where Roe gives us this high, close to a fundamental right standard. Gonzalez goes all the way down to a rational basis standard. And then Whole Woman's Health kind of corrects and comes somewhere in the middle between the two. It's almost as if it's in conversation with Gonzalez and the Ginsburg dissent. So we can come away from this. The key points I want you to take out of this is there are huge fluctuations in jurisprudential understandings of how strict or how deferential the court needs to be in reviewing a law that regulates access to abortion. But Casey is still the standard. Casey is the flag, the interpretive flag that everyone is fighting for, to define whether Casey requires a rigorous review or a more deferential review. So my question for you all that I want us to think about is this a broad opinion or a narrow opinion? And in the interest of time, I don't want to spend a ton of time talking about this, but I want to flag it because that's what's at stake right now in the U.S. Supreme Court. So this was a Texas case, the case that's going up in June Medical Services v. Rousseau, that's pending right now before the court and that will likely be decided before our class is over, is a case that involves almost identical legislative provisions to what Monica and Teresa described for us in Louisiana instead of Texas. And so there's a lot of language here that suggests that this was all about Texas very narrowly, or there's a lot of language that's saying, let's just finalize the standard, and here's what the standard involves, and apply it going forward. So we have 2 new justices on the Supreme Court from where we were before, and an almost identical law that came before the court in March. So we want to watch carefully, and I want to flag this because we will talk about it whenever it happens. We will talk about this in our class. So let's talk about the concurrence here. So I have Elizabeth for Justice Ginsburg's concurrence. What does she say now? She was super upset in Gonzalez, but she's still concurring here, even though I said this was a direct response to her.
Right. What I take away from it is that, you know, she agrees mostly with it. She says there's many other procedures that are more dangerous than abortion. This law is not narrowly tailored, and it isn't even rational. She says it is beyond rational belief that HB2 could genuinely protect the health of women. So I think she just wanted to emphasize the part about protecting the health of women in addition to fetal life.
Good. And if she could, I'm going to put her over here just so I can say I used my slide. If she could wave her wand here, that's Ginsburg. If she could wave her wand here, she would say, all right, let's get to work, guys, and strike down every law that has been passed in the last decade that doesn't really seriously protect women. So she is suggesting that this opinion has a more expansive reach and could theoretically apply to every law like these here, where they were passed to create obstacles instead of to help. So she's trying to take the opinion and expand it beyond its current interpretation, or beyond a Texas narrow interpretation. Tanner, let's talk about Justice Thomas's dissent, which I think is brilliantly on point, and I don't say that often. So let's talk, Tanner. What does he have to say here about how this law has developed, this jurisprudence?
So Thomas is really mad that they're moving. He says that they're moving towards strict scrutiny rather than the standards set forth in Casey. But he also kind of argues that in cases where there's medical or scientific doubt to how things will be, that you should just leave it to the state legislature and it should be rational basis. So like he's arguing that the majority is moving towards a strict scrutiny application of Casey, but he wants it to be rational basis review, basically.
And what would he say about our entire 2 weeks of class and all the cases we've developed? What would he say about the line of cases?
Oh, he doesn't like it at all. He thinks it shouldn't be a thing, period.
Good. And if you put your politics aside as to what the law should be, and just take his descriptive account of what is actually happening, he's basically saying every time we talk about this, we use a different standard. And Justice Ginsburg was effectively saying the same thing in her Gonzalez dissent. Like, hey guys, we just switched the standard. We shouldn't have done that. And Justice Thomas is saying, hey guys, we just switched the standard. We shouldn't have done that. And I think it's a really important, fair critique, because it actually builds your confidence as students. If you're like, good Lord, every case we've studied in this entire class so far seems to move the needle as to what we're talking about, then you've mastered it. And Justice Thomas has summarized it well for us. But it also reveals going forward really important questions about where this type of case will go in family law. And then finally, Liz, talk to us about the joint dissent with Alito, Roberts, and Thomas. Oop, Liz, are you there? Liz Sebastian?
Yeah, sorry, I couldn't find the tab with the thing. So, sorry, what was the question?
The dissent. What is the, there's a joint dissent with Alito, Roberts. What are they upset about?
Kind of like how they think that the case should be barred because of the res judicata, the claim preclusion or something.
Good. And what would they have done instead with the causation stuff?
I don't know. I didn't have it in my book, so I read it on Westlaw. So
sorry. Well, they would sit over here, basically. I'll put them over here. And they would sit over here, and they would say that this case should have been remanded to get better clarity about causation. Is this really why the clinics closed? And in some of the jurisdictions where clinics remained open, the law should have been allowed to take effect. So they would slice this very narrowly, and Ginsburg would say, let's get to work and start gutting every law like this in every other state. So that's our look at the right to privacy and the extent to which it includes the right to terminate a pregnancy. So let's look, let me close my slides here to give ourselves a break. Let's take a look instead now at Lawrence v. Texas. And this is the sort of capstone case that really bridges us beautifully into the marriage cases. And so I have Johnny first to start us off in this case. So tell us what the statute is here. And then tell us the facts of what really happened here.
So this is a Texas statute. It's the Texas Penal Code 2106A that talks about same-sex intercourse and the banning of it. And so what happened was that there was I'm trying to read my notes, I'm sorry. So there was a police that went into the home in which they observed two same-sex couples engaged in sexual acts, and they were arrested based on this statute. And both parties argued that the statute was a violation of the Equal Protection Clause. And it went all the way up to the Supreme Court, and the Supreme Court reversed the decision based on the fact that the statute justified its intrusion into the personal and private lives of the individual.
Good. So here, I hope you guys read the narrative that went along with this, because, and we'll talk about it in a moment, but there is important context here if we go back to thinking about the right to privacy through the lens of relations. Here, importantly, the court is about to tell a very beautiful romanticized story about intimate associations that doesn't at all fit with what actually happened in this case. So the Lawrence, the litigant here, does have a boyfriend, but it is not the man that he has found with. This is not an intimate relationship. It is sex, right? And it's going to matter because the court's going to work really hard to put this sex in like a white picket fence, but that is not actually what's happening here. We'll talk about why that matters in a moment. Let me switch to Nathan and let's talk. So how does the court describe the issue? Did you catch in your reading the exact framing of the issue here? Because it's very significant to where the right to privacy is about to go.
Well, there was a big focus on consenting adults, why they should be given the privacy and intimacy, and the state should stay out of that relationship.
Good. And we talked, so there's one way, let me direct your attention to the issue statement. Where is it?
It's an issue statement on page 63.
Oh, you're my hero. Can you read it? Because now I've got the other version of the book in front of me.
The issue is whether the majority may use the power of the states to enforce the views on the whole society through operation of the criminal law.
Good. So you can, when you read that now I want to do something fun. Read that again one more time, Johnny.
The issue is whether the majority may use the power of the state to enforce these views on the whole society through operation of the criminal law.
That sounds a lot like Griswold, doesn't it? Where the court is super upset with the state, the criminal arm of the state particularly, storming into the marital bedroom of the couples. Does anyone have a different, you could find probably 6 different statements in here that you would identify as the issue. And it really solidifies my point about how murky the right to privacy is. Someone read something else that you identified as the issue.
We conclude the case should be resolved by determining whether the petitioners were free as adults to engage in the private conduct in the exercise of their liberty under the Due Process Clause of the 14th Amendment.
Beautiful. Listen to that one. Free to engage in private conduct and exercising their liberty. That sounds more like decisional autonomy or maybe relational autonomy. Totally different than the version, but you can see all 3 packagings here in Lawrence. Good. And the version that Elizabeth read is also really interesting because it says free to engage in private conduct. The reason that's significant is up until this moment, every time we've talked about the right to privacy, we've talked about the right to privacy in a negative rights lens, more like the issue statement Johnny read. Keep the government out of your bedroom. That's a negative right. You can't come in here unless you have a warrant, unless there's a good reason to regulate in this private space. But the version that Elizabeth read is a positive right, a freedom to engage in exercising liberty. And if you look up at the top of your casebook, you'll see that this section is called the liberation of privacy, where we take privacy and we put it in the lens of liberty. Why is that so significant? Because if we go back to this time in class last week, we were talking about where the litigants in Poe really wanted to start. They always wanted to start with liberty. They always saw this as a liberty issue. And then we took this total long turn, and now privacy is still packaged. Liberty is packaged into this privacy issue. But you can see that this moment is like the linchpin allowing us to get to where we ultimately get in Obergefell. But it's a very different framing. It's a right to do something or freedom to do something. Good. So let's talk about Bowers. So let's do an all-in here and get everybody awake and chatting in the chat box. How does the court dismantle Bowers? It's super important because if we think about Roe and where our court is heading, we might not be far off from a case doing this exact same thing to Roe. What are the strategies that the court follows to set aside the precedent that stood in the court's way before it could reach this ruling? How does the court get around Bowers? Chat it out. Good. So it questions its historic value and its historic context. So Bowers told this story of the state always regulating this conduct, and Lawrence is like, hey, no. For most of history, law has never said anything one way or the other about people's sexual practices. And so here, the court told a very narrow story suggesting we were always hyper-regulating in this particular area. The court, as Ellen tells us, looked at cases that discredited Bowers' holding. Brian tells us that it looked at how we socially have moved away from it, that it's eroded as a social concept, and that we think very differently about intimate conduct today. And all sorts of ways in which the court works to set aside. And it also uses Casey. I want to read this language because it's freaking beautiful. This is the language from Casey when Casey, yes, awesome. Dimitri just shouts this out as well. Casey said that what is at stake is the liberty to define one's own concept of existence, of meaning, of the universe, and of the mystery of human life. That's how it defined what the right to privacy was. That's a very strong decisional, like self-actualizing and freedom kind of lens, and Lawrence ultimately adopts that as well. Dimitri also mentions Romer. I'm going to mention that just as context for our 2Ls, none of whom have had con law yet. Romer basically says that if a law is passed for the purpose of harming a particular group, then we'll apply like a heightened scrutiny to looking at that particular law. And so similarly here, the fact that this law was regulating a particular kind of conduct among same-sex couples suggests it was targeting an entire classification of individuals. All right, now, for the $64,000 question, the grand finale of Lawrence and everything we've been building up to dramatically for 2 weeks, what standard of review does the court apply? And I really want everyone to answer in the comments here, because you will see a tremendous range, and Brian and everybody's beautifully starting us off with a question mark at the end. Rational basis? Strict scrutiny? There are also some spots here where you could almost pull out the undue burden test. For those of you who have had con law, there's some language that suggests it's intermediate scrutiny, something in between. Lawrence is a transformative case to how it uses the right to privacy. It liberates the right to privacy to be a liberty interest, much more like what we're going to see actualized in Obergefell. But it leaves a massive question of what standard of review it is applying. Now, I want to talk in closing on this case briefly about the split. So when you get to your exam, you will either have a classification, which we will do an equal protection analysis on using our standards of review, or you will have a fundamental right that is being infringed, and you will do a fundamental rights analysis, both of which take you to my chart from the beginning of class. But notably here, the majority is doing a fundamental right analysis, and that's super important. And we'll talk about it with O'Connor's concurrence in a moment. But it is doing a fundamental rights analysis using the right to privacy as we've understood it before, but it is leaving to Justice Thomas yet again, leaving open tremendously what standard of review governs the right to privacy. And so for our purposes for the exam, you're going to want to move toward bucketing cases. What are the cases or the arguments that work best for the state and that work best for the petitioner challenging the law? So let's talk about, so the huge question about what standard of review is applied. I want to put my slides back up for a second. Someone tell us, the real story here, I sort of alluded to it already, but it was very different. It's really like hate sex, if you want to be serious about this, right? It's revenge sex. That's the word I'm looking for, right? Like Lawrence has an actual boyfriend and he was at the restaurant with them previously. Lawrence leaves the restaurant, goes home with this other man, and Garner, the boyfriend, calls the police on his own boyfriend. The police show up and he invokes race, notably white man invokes race to get the police to storm into the apartment, says he has a gun. They go into the apartment and see this act. In the comments, let's talk for a moment. How does that jive with the court's version of the facts? Does the court follow those facts, or does it sort of tell a very different story? Let's try to find some examples from the case. I sort of alluded to the answer already, but where is the evidence of it? What does the court say about this couple, about this right, about this relationship, and what is being protected here? What does it say about sex? If you need to look more directly. Good. So a couple good examples in the comments saying, so Brian's example highlights that there is an autonomy, a decisional autonomy here for us, but there's definitely some really beautiful language that doesn't really Yeah, so they talk a little bit about, they say the one thing they say that really catches my attention is they say sex is but one element in the opinion of a personal bond that's more enduring, telling this really strong story. Let me get my slide up that pulls out some examples of this, that tells this very beautiful story of almost like a love story that is not actually present in these particular facts at all. Hold on, let me get my right slide. Here we go. So if we look at hold on. Here we go. So these are excerpts from an article written by a Columbia law professor, and she talks about how there's this really strong liberty interest here, but she calls it the domesticated liberty, that this opinion could have been something far more liberating that would really change the way we think about the role of the state in relationships. But the court is definitely telling a more cabined version of liberty here that doesn't even really clearly align with the facts in front of us. Let's talk about the concurrence for a moment. This is all the right to privacy piece of it. But let's talk about the concurrence for a moment. And I have DJ for that. What is the court, what does Justice O'Connor say? Everything we talked about here has been on the right to privacy.
She focuses it more on disapproval or perceived immorality of same-sex couples, as opposed to the right to decide who you will or will not have relations with.
Good. So if we think about your exam, when you get your exam question, and in preparation for class next week, when you take some practice exam questions, when you read the question, you're immediately going to hit a fork. And the fork is this. Does the law that I've given you, the law that's probably unconstitutional, does it regulate a fundamental right, like the right to marry, the right to contraception, the right to terminate a pregnancy, the right to raise or rear one's children, or does it treat two classifications of people differently, similar classifications differently? And so DJ tells us that Justice O'Connor says, hey, wait, what this law is really about, it goes back to Johnny's articulation of the statute. The statute was about same-sex couples in these acts, but opposite-sex couples doing the same acts would not face a criminal penalty. And so the law is both. So for issue spotting on your exam, these are the only possible topics I can test you on. And often almost always I test on both, where it is both a classification and a fundamental right. And so Justice O'Connor says, we should really be talking about this as an equal protection issue because we're treating a classification, a class of people, in this case, same-sex intimate partners, differently than we treat opposite-sex intimate partners, and they are similarly situated for this purpose. And so that she's concurring, she ultimately agrees with the opinion. Were she right, then the court could just the state could just rewrite the statute and ban all of the conduct, much more like Bowers. And that's what Bowers had said. Bowers had a statute that banned all conduct without regard to who was engaging in it. Brian, Ellen, I realized I skipped you, and I promise I'll get back to you next week. Brian, let's talk about the dissent here. What does Justice Scalia say about the scope of this opinion and its impact on the right to privacy?
Yeah, so Rehnquist and Thomas joined Scalia, and Scalia said the majority doesn't provide a sufficient basis for departing from the precedent in Bowers, and that Bowers held that the right to this form of sexual relation wasn't a fundamental right, and the majority doesn't even say otherwise, and instead they apply a rational basis review, and basically this can invalidate anything on morals, and it brings up, he said, whether the impacts it will have on prostitution, adult incest, adultery, obscenity, and child pornography, and yeah, that's the gist of it.
Good. So he does two things with this. One, he's sort of like, fine, if you get this, then I get Roe, right? And you can see him starting to trace exactly how the logic of Lawrence could also lead to the same outcome in Roe. And then two, he suggests that that we could go after, under this logic, any other law that's regulating sexuality or morality, suggesting huge implications for this opinion. The last thing I want to say before we move to our marriage line of cases is the significant point about the future of Roe. So in Lawrence and in all of the cases we're going to study for the rest of our time tonight, every one of these cases include both the question of equal protection and a fundamental right. And the court looks through two separate constitutional lenses. I want to make sure I say it explicitly because it's not super obvious, but abortion and the question of when the state can regulate to limit access to abortion has never been given a gender equality lens. It has never been looked at because the Roe case preceded the court looking at state laws with heightened scrutiny to sex at all. But that's important because we're about to end class today, or probably we'll do this next week. But when you get to Obergefell makes a major move to our doctrine, and it does what some scholars have called a double helix. It weaves together the equal protection and the fundamental rights notions into one link that is stronger together. Importantly, when we think about Roe has only half of that strand. It has only the right to privacy strand. So the move in Lawrence and the move in Obergefell, where the two are being talked about together, has significant implications for the future of abortion access as well. So I want you to be savvy as you watch those cases develop and think about how that right stands on its own with just the right to privacy. So next, let's look at Loving. And I have Annie for this first. So tell us what the statute was here and why the law was passed.
The statute was the Racial Integrity Act, and it was prohibiting a white person from marrying anyone other than another white person. And it also gave guidelines to who could, or issuing a marriage license, where they needed to confirm and believe the applicant's statements of race, and then also record those racial compositions in the state and local registers.
Good. I'm going to interrupt rudely for 1 second. I hope you caught in the notes here, Virginia, my now home state, still asks that question in a marriage license application. And there's a current case brought by the Virginia ACLU to strike that down, because it's a relic of Jim Crow era white supremacy legislation. But the question of your race has not been stripped from the marriage license, just if you're curious. Go ahead. Sorry, keep going.
Okay. So their bases for the statute were to preserve the racial integrity of its citizens, to prevent the corruption of blood, a mongrel breed of citizens, and the obliteration of racial pride. So just like truly white supremacy.
Good. This is probably the most explicit. Other states, there were a total of 38 states in the Jim Crow era that had laws like this. This is one of the most explicit in candor as to why it was doing what it was doing. Unmitigated legislation for the purposes of perpetrating or perpetuating white supremacy. And tell us about the couple, the Lovings.
It was a mixed woman and a white man. They grew up together and wanted to get married. So they went to DC, I believe, and got married where it was legal. And then when they came back to Virginia, they were I think ratted out for being married, and then prosecuted. They pled guilty. I think, is this right that they pled guilty because they wanted the lighter sentence, knowing that they would get the sentence dismissed for being out of the state for 25 years or whatnot?
Good. And so they were forced to move to DC, and the difference between DC and rural Virginia is dramatic. So challengers, the petitioners, the Lovings, bring two tandem claims. What are they? This is how we're going to approach every question for the rest of our class. What is their theory of this, strike this down as unconstitutional? Is it equal protection or fundamental right, or both?
I don't think I understand the question.
So, well, let me just ask it outright. Does this law infringe on any fundamental right?
Yes.
Which one?
The fundamental right to. I think I'm confusing myself.
I actually think you're overthinking. Yeah, you're overthinking.
Yeah,
Just the right to marry or the right to privacy. So, but ultimately, it infringes on the right to marry because it says they can't marry. That is the biggest infringement you could possibly imagine on the one side. So let's imagine this for our exam question. We're at a fork in the road and we issue spot. Does this infringe on a fundamental right? Yes, the right to marry. And we'll talk in a moment about how that's going to become a fundamental right. And then, Annie, what about the Equal Protection Clause? Does it treat similarly situated classes of people differently?
Yes, it does.
Good. And the government challenges that and says, well, it doesn't really, because everybody's prosecuted equally. We're not only prosecuting one race, we'll prosecute every race equally. But the court nonetheless sees through that the equal application of the law doesn't change the fact that it is an unequivocal racial classification. And particularly for the 2Ls, just get this in your notes and memorize it forever. If you see a classification on the basis of race, that puts you using a strict scrutiny lens. So we already are familiar with the strict scrutiny lens, but that's what we would apply. We would look with the most rigor, the most suspicion, the least deference to the state when it regulates on the basis of race. And so the court looks at equal protection first. I have other people on call for this too, don't I? Damien, are you on call for this too? Damien, are you there? Oh, he left. Okay. Annie, I'm so sorry. Oh, I have somebody else on deck. Who else was helping? Who else was supplemental with this?
Nope, just me.
I was supplemental.
Someone was. Who just said that? Monica, why don't you jump in also? And Annie, you win the award for being on call for the longest time ever in a summer class. Monica, jump in and tell us with the equal protection analysis, how does the court go through that analysis? Can you get your volume higher? Sorry, it's a little hard to hear you.
So for the equal protection analysis, it's completely based on the classification, and they point to the fact that the purpose, like we said earlier, that it was just based on white supremacy, is definitely not a compelling objective, and it's also not narrowly tailored in any way. It's not even a compelling objective.
Good, perfect. The court and does the court, Monica, even really, truly, authentically apply the strict scrutiny test?
No, they really don't.
They're unequivocal that this statute is a hard no. It's an easy unconstitutional, even under just the rational basis test. So the court says, no question, this is unconstitutional. And its holding is under the Equal Protection Clause. The interesting part about this, I'll come back to you, Annie. The interesting part about this is the court does this equal protection analysis. The statute's dead. It's now unconstitutional. But nonetheless, the court continues and it talks about the fundamental right to marry. And what does the court tell us on that point?
That to deny this freedom on such an unsupportable basis, such as race, is to deprive all of the state citizens of the liberty under the Constitution of the freedom to marry whoever they choose.
Good. So the court goes a little further, but the interesting thing is, if most of you probably think of Loving v. Virginia as like the iconic, historic right to marry case, but really the official holding is unequivocally on an equal protection grounds, striking down the racial classification for access to marriage. And then the court continues in what might arguably be dicta to give some very powerful language saying that marriage is one of the basic rights of man, fundamental to our existence and survival, citing Maynard, the case you read for last class, suggesting that this is a fundamental right. So if I were in class and drawing on the whiteboard in that big right to privacy, where we've plotted contraception, we've plotted the right to terminate a pregnancy, and we've plotted intimate association, we would now dramatically add the right to marry with a tentative cite to Loving, but only tentative because it's not the holding. And in the end, watch this for the entire rest of our course, you will almost never see Loving cited on its own. It's almost always the trilogy of Loving, Zablocki, Turner cited together always and forever. So let's look at Zablocki. So this is a significant case, Loving was, because it clarified that like contraception, marriage is also a fundamental right subject to the highest, potentially to the highest level of scrutiny. But the court was already applying high scrutiny because of race. So we don't really have a ton of clarity just yet. So Holly, let's turn to Zablocki. So what is the statute at issue in Zablocki in Wisconsin?
Sure. So the issue here is a Wisconsin statute that basically says that if you have, it's preventing people from marrying if they owe child custody or if there's a chance their child could eventually be on welfare, is how I read it. Mm-hmm. And so basically what happens is a guy who had never been married before went to get married, and they said, oh, even though you've been unemployed for these years, you owe this back child support, and you have to pay it or you can't get married. But it read in the text that even if you had paid it, his daughter would have still had to been on welfare, so he would have not been able to get married either way.
Good. An incredibly powerful statute. And why did the state say that it was doing this? What was its supposed reason?
I think their reasoning was they wanted to incentivize people to pay child support.
That, yes, and a couple of other things that were a little more tenuous. Yours would get a lot better. It would be a better law than what Wisconsin actually did here. Olivia, do you want to jump in?
Yes, I'm looking for it.
It's a helpful point to nail down precisely because it really reviews this concept of the fit, whether the means selected are appropriate.
I think, are you talking about how they said that they were counseling him about his support obligations and that they wanted to ensure that children not in the person's direct custody received support?
Exactly. So the court's official reasons for enacting this law were to create the opportunity to counsel the applicant on the importance of support and to protect the welfare of out-of-wedlock children. So the question now becomes, is this a classification or is it a fundamental right or is it both? And Holly, how does the court work with this statute? It's very tricky.
They say that it is a fundamental right, and then they apply strict scrutiny, and they talk about Loving versus Virginia.
Good.
So they said it's also part of the right of privacy.
Good. They also are simultaneously slightly talking about the Equal Protection Clause because it is creating a classification. And one important point I want everyone, including all of the 3Ls who are constitutional law savvy, whenever you think about classifications, for our purposes, do not only look for classifications on the basis of race or gender or legitimacy. Any classification would merit a constitutional review. It's just that a something that does not invoke a suspect class would only get rational basis, meaning it's presumptively constitutional. And so here, importantly, there is both a fundamental right at stake, the right to marry, but also there is a classification. People who want to marry who have child support debt and people who want to marry who don't. That's still a classification. It's just that it would get a rational basis. But importantly, you'll see tons of classifications in family law that are presumptively upheld. So we're not only looking for race or class, we're looking for any classification. So the court does something a little funky here, which is why we need the trilogy. Even this case isn't a pure fundamental rights case. It really does this funky thing and takes this classification and says, hey, the law is regulating a fundamental right, so we have to look really carefully at it. But the opinion reads very murky, the majority, as to whether or not it's equal protection or whether it is a whether it is a fundamental rights analysis. And then when we get to the concurrence, Justice Stewart says, hey, we should apply the 14th Amendment. And I hope some of you, when you got to that, were like, didn't we just do that? It's a little murky what the majority is actually doing, which is why you'll always see all three of these cases cited together. But Holly is spot on that this is the case that says in beautiful terms that Loving does not say so clearly, marriage is a fundamental right, and we have to critically examine statutes that regulate it. The court then does a notable thing, and it creates a fork in the regulation of marriage. And I want to mention that, and then I'll wrap up. But I want to mention that because in the work that you're doing online this week, you're reading state regulations that limit access to marriage, and you'll see that not all of those will be subject to strict scrutiny. The court says reasonable regulations will only get rational basis. So, for example, I was having an email exchange earlier today with Ellen, and we were talking about the provision in Kentucky law that says once you get a marriage license, it's only valid for 30 days. And the question is why? What's that about? Why are we trying to do that? It's really complicated for folks with international marriages, managing citizenship and visas. But importantly, that would not get strict scrutiny if it doesn't significantly impact the right. It's a small regulation. Here, we have a complete ban. Obergefell, complete ban. Loving, complete ban. So these smaller regulations, more like what you're doing in your online content, would get a much more minimal review. All right, so I'm going to stop there. I want to be very sensitive to time in a night class, but we will pick up here, and then we will continue with practice problems. So we'll spend probably 15 minutes, 20 minutes wrapping up this material next week. And then the whole rest of it, we will do practice problems. So I'm going to look and trim if we need to. And I'm going to assign groups for practice problems, make sure some folks are very rigorously ready on a particular question. So let me wrap up here. I'm going to stay online like I did last week, and I'm happy to answer questions. But I want to officially end class and stop the recording. You guys did a great job. It's a long time to do more like lecture-y kind of stuff like this. But next week, we'll get much more active and move into a lawyering and exam readiness frame. So great job to